Thank you very much all for coming for day 2. It's a great pleasure to be asked to moderate this session, and I'm very pleased to be able to introduce to you our 2 speakers. Firstly, can I introduce David Muss. I had to speak to them beforehand, so I knew how to say their names. So that's David Muss. He's the program manager at Cisco in London. He left Groningen University to work for KPN in The Hague and later for Cisco in Turin and London. And intellectual property has been a continuous central theme through his professional career, and he studied civil law with an emphasis on IP, supplemented with several postgraduate courses and degrees in IP law. David has also been educated in the technical side of communications with a strong focus on mobile and IP networks, which I'm sure stands him in good stead for his current post. Before joining Cisco in 2015, he acted as IP counsel and patent licensing specialist at the Dutch incumbent telecom operator KPN. At Cisco, David started out from Turin and is now based in London, where he supported and managed the LTE patent pool until the end of 2017. Now David is responsible to make sure that the patent owners of the mobile communication program and the implementers of the 3G and 4G LTE technology find each other and resolve any infringement in a harmonious way through Cisco's platform. The mobile communication program licenses the 3G and 4G LTE essential patents of 3G licensing, Airbus, DS, KPN, Orange, Mitsubishi Electric, and Cisco itself. And our second speaker today will be Tali Dvorkis. She's a Senior Associate International Intellectual Property Group at Allen & Overy LLP here in London. Prior to joining Allen & Overy in 2016, Tali practiced for 6 years in a top New York law firm doing contentious and non-contentious IP with a focus on patent litigation for TMT clients. Tali previously served as a judicial intern for the Honorable Richard Lynn of the U.S. Court of Appeals for the Federal Circuit. Tali has a Bachelor of Science degree in physics from MIT and graduated cum laude from the University of Pennsylvania Law School and has attained a postgraduate diploma in intellectual property from the University of Oxford. Tali is admitted to practice in England and Wales and New York and is a registered patent attorney before the USPTO. Tali specializes in cross-border patent disputes for TMT clients and has expertise in standard essential patents and FRAND licensing. And Tali regularly writes on comparative aspects of US and English law as well. Now, before I go on to ask our speakers to do their presentations, I can do a little bit about myself and the company I work for, which is Avidity IP. So my name is Juita Murphy. I'm a European and UK chartered patent attorney, and I work for a firm called Avidity IP Limited, which is not a partnership, it's a limited company, and we focus entirely on life sciences, medtech, pharmaceuticals, chemicals, so anything that doesn't have any engineering or physics base in it at all. So we're a globally experienced firm, in operating, which I've just said, and what we particularly pride ourselves in is in challenging cases before the European Patent Office and before the UK courts as well. And yes, so what we find is that we're able to go that extra mile for our clients and provide the client care, which some of the firms might not be able to, and we have a reputation in dealing with very difficult cases. We now have a mission statement which ensures that we provide commercially focused, high-quality, specialised patent services globally in the life sciences, pharma and medtech sectors, and we place clients' needs first and have a culture of care and consideration for clients and staff alike. We offer the full range of services in UK and patent matters. That's drafting patent applications, filing patent applications UK, Europe and PCT. We do PCT national phase filing. We do patent prosecution through to grant. We defend patents in European oppositions and in appeals. We help to oppose your patents in Europe. We also do the supplementary protection certificates and pediatric extensions on patents. We support the litigation in pharmaceuticals or life sciences areas. And we also do patentability searches before you're filing a patent application to make sure that you actually have a space to file your patent application and get one granted. We'll also do trademarks and registered designs, trade secrets and know-how management. We provide a wide range of strategic IP services, which we find is really important for our clients. We'll do an audit of the innovations which need protecting. We'll do portfolio management and planning. We'll do freedom to operate opinions, any due diligence opinions. We'll look at a competitive landscape as well as risk management analysis. We offer an IP formality service, which is renewals, recordals, assignments, European patent validations, and then, of course, the upcoming unitary patent will become very important. I already mentioned the due diligence side of things. We'll also do training in-house for any clients that need it or feel they need an awareness on IP matters. So that's our team. We're a team of about 8 attorneys. 8 attorneys. There's myself, there's Richard Bisley, who's been involved in very high-profile cases like the Harvard Oncomouse and PCRs, and some of you may already know of him. We have Dr. Gwyn Cole, who used to be head of IP at Merck. We have Dr. Suleiman Ali, who specializes in the life sciences and the emerging life sciences tech. And we have Magda and Andrea, both deal with life sciences and med tech, as well as Gary and Kevin, who specialize in the med tech and slightly more engineering side on the med tech side of things. So with that, I shall conclude my pitch on the company, Avidity IP, and I will introduce David, who will speak first. Thank you.
Should I go up there as well? Or?
Yeah.
So, Juwita, thank you for the kind introduction. So, as Juwita already indicated, I work for Cisco. As we've got a little bit of a mixed crowd, I got a little bit of an introduction in our company as well. The clicker. Sorry. That works. So, Cisco was founded in 1982. It was basically a joint venture between Italian television manufacturers. What they noticed is that they were attacked a lot by German television manufacturers on the basis of their patents. They tried to push them out of the market that way, and the Italians got together as well, and they joined up in a patent pool of sorts, and they defended themselves against the Germans that way with countersuits and defensive actions, etc. While these two national issues were resolved, in the meantime the Japanese were taking over the television market in Europe. So after that battle was settled, basically the Italian television manufacturers stopped making televisions and they went back to making white goods. And Cisco still had this trove of patents on teletext, on-screen displayed kind of technologies, etc. in this joint venture. And this is basically where Cisco's current activities were born. Over time, we have been engaged in various technologies, starting mostly with video coding in the beginning and going to audio coding. Cisco's got its famosity, I guess, if you're aware of it at all, from the MP3 program. At some point in time, I think about 80% to 90% of all MP3 capable devices were licensed through Cisco, which was a pool which represented about 70 to 80% of all patents in that particular field. The program has had a long life. I think it ended about 2 years ago. And in the meanwhile, we've been developing other activities as well. So we've been mostly focusing on standard-heavy technologies. We've been involved in DVB-T, DVB-T2, which is basically terrestrial television, digital television over the air. And since 2012, we've been engaging also in 3G and 4G cellular technology, beginning with Cisco Wireless, which is an acquisition of a Nokia portfolio, which your company did. And later we built patent pools around those offerings as well, which led to the LTE patent pool and the 3G patent pool later on. Previously, I've been the manager of the LTE patent pool, and only February this year we combined all the cellular activities into one program, which we now call the Mobile Communication Program, which in effect has been a little bit of a result of the subject of the discussion of today, which is patents and standards and FRAND licensing, basically. So I understand there's also a fair amount of people from pharma here who may not be aware of all the details of essential patents, as it is less important there. But basically, an essential patent is a patent that has been granted with claims that are covering technologies which are part of a standardized technology. So when all these innovating companies come together, companies like Ericsson, Qualcomm, Nokia, all the telecom operators, they come together. They come together and they think, well, what should LTE be? What is the next step in cellular telecommunications? They pull together all the ideas, and through a very, let's say, delicate and political process almost, they come up with what is the standard. So they trade technologies, engineers get together, they decide what is the best technology. There's a little bit of bargaining as well involved, because every company wants to promote their technology, of course, because that's what they know best how to put it into infrastructure as well. And as a result, you get this big chunk of technology of combined inventions, which make up the standard, basically. Now, most of these companies also got patents. Some companies who do not participate got patents on these technologies as well. And the result is that you will have standard essential patents. So to use the standardized technology, you have to use a patented technology as well. And that comes with a lot of issues. So as you may understand, not being able to use a system which is used worldwide because of one patent on one technology in this group of technologies creates an issue which many of the regulatory bodies around the world have indicated is an antitrust issue. So basically you get an unfair monopoly by using one patent, by blocking an entire standardized technology. So this is where the whole discussion of FRAND comes from. And I understand that Tally will go deeper into the details, what FRAND means. It's a discussion which has been ongoing for about, I think, 15 years, my entire career at least. And what I always find odd is that nobody really knows what to say, what FRAND actually is. So it's always the fringe issues which are discussed. Everybody has got a gut feeling what FRAND is, what is right, what is wrong. But nobody can really tell you this is FRAND and this is how you should do it. So basically, what is FRAND? It's a balance of interest. FRAND stands for fair, reasonable, and non-discriminatory. In the US, it's called RAND, so they take away the fair, basically. It's just reasonable and non-discriminatory. And it's basically a balance of interest. It's the standardization bodies, they started with this. They said, look, if you're going to submit your technology to the standardizing body, you have to commit that you will not use your exclusionary right, which is your right as a patent owner, to block the entire standard without also offering a license on FRAND terms. Then that means that they got a contractual commitment to license their patents under reasonable and non-discriminatory terms. So they have to treat everybody the same, or at least equal cases under equal terms. And you cannot ask for the world. That's basically, in a nutshell, what FRAND should be. Then this contractual commitment of the standardizing bodies later on has also found its way into antitrust. So what you see, for example, is that from the European Commission, they also, especially the DG Competition, they found their way how to integrate this narrative of FRAND licensing into the broader antitrust regulatory field. So even if you're not part of a standard, if you have never submitted to a standard, you don't have the contractual obligation, you still have the obligation to license on the FRAND terms, because otherwise you may be using an unfair market advantage. Now, just to give you a little bit of an interest indication, what is the balance of interest we're talking about? If you're talking about standardized technologies, especially in the field that I'm working in, mobile communications, it's all there is, basically. So everything which is in your 4G LTE phone is in the next phone as well. So they have to use the same things. Now, if you look at previous technologies like DVB-T, MPEG, the investment in MPEG was about 190 million to get that technology going. DVB-T is about 100 million. If you look at what companies like Ericsson and Nokia are investing in 5G year on year, 5G IoT, they're looking at a budget of about 4 to 5 billion right now. If you go to China, it's even more impressive. If you look at Huawei, where we're nearing 18 billion in investing in those kind of technologies. And of course, there's some non-essential in there as well, but most of it is essential because that's what their products are. So FRAND tries to strike a balance between the interest in the investments in the technology, but also in the interest of the public of getting access to these technologies. So it's also granting access to the market of new market entrants who do not have research and development or very limited research and development or have competing research and development to use the patents and the technologies of these protected companies. It's a delicate balance because especially how things are moving, so the companies I mentioned, Ericsson, Nokia, they don't make phones anymore. They all come from Shenzhen basically. A lot of the companies there now also do a lot of research and development, but there's also many of them and they account to 30 to 40% of the market who do barely any research and development at all and do not participate in standards even. But they use the same technology. So this is where FRAND licensing gets very important. And I think it's stating the obvious to this crowd, I think, but basically it's what we call, what is the Inventive Loop. So there's basically two ways how to monetize research and development. The first one is you invest in research and development, you create intellectual property, you put it into a product, you sell the product, and you profit from the product. If you don't have to invest in research and development, of course, there's an imbalance. That means that you have had a cost which your competitor doesn't, and they have the same product. So there's an additional monetization loop, which is intellectual property, licensing turns into another product which you can put back into R&D, and the circle continues, and eventually you should be profitable, because otherwise why would you invest? One of the landmark cases in recent years, 2 years ago, 3 years ago maybe even, is a European Court of Justice decision, at least here in Europe, which has defined the field of licensing a lot. Basically what it said, it was a case between Huawei and ZTE, two Chinese telecommunication manufacturers. They were fighting it out in Europe for various reasons. They didn't like to do that domestically, to be honest. And what the ECJ came up with was basically a sketch of what should be the steps in the licensing process while dealing with essential patents. And this is important because it's always been a question about essential patents. Can you get an injunction? In the US, it's very difficult, if not impossible, to get an injunction right now. There are some sounds that this may be changing under the current administration, especially the DOJ anti-competition, antitrust division has had some speeches suggesting that it should be reverted. But in Europe, they took a different approach. They said, well, there are injunctions, also in essential patents, but only if you have behaved according to particular standards in behavior. And the first one is you have to notify somebody of your patents. They should know they exist. You cannot just rely on the register and say, look at the register, they exist, that's what the register is for. You have to actually notify them of the patents specifically and explain the way the patents are infringed. And this is usually done by showing the relevance of the claims to the particular sections of the standards that are used in the products or to map them to the products directly. Then the second obligation, and this is where the decision I think is fairly balanced, it also says there's also an obligation on the infringing side. So the infringer has then to express that it's willing to take a license under FRAND terms. Then there's a third step, again with the licensor, with the patent owner, and he has to provide a specific written FRAND offer, including an explanation of the royalty rate. I think that most of the litigation which is ongoing right now in Europe and also to some degree in China and India is what are those FRAND terms, what is a FRAND offer, and what is the explanation of a royalty rate, and what should the result be. And then the fourth step is on the infringer again, is they have to have a diligent response to the offer, either by acceptance or by a written specific counteroffer, which also should conform to FRAND. In the decision, which I think has a little bit less attention in courts right now, there's also a specific attention that there should be focus on if delay tactics are being used. And I'll get to that later, because in my job, that's what I have to do with a lot, is particular delay tactics to stretch this process out as much as they can, usually to 2, 3, sometimes even 5 years before you get to resolution. So we're a licensing company. We license standard essential patents. This has a lot of impact on us. We basically have been waiting for the decision about a year before we knew actually what we should be doing. There was an Attorney General guidance first, which was much more heavy, so it was a little bit up in the air for a while. And what we see right now is that what the European Court of Justice did is now being implemented by the European Commission as well. And what we also see is that, for example, governing bodies like the NDRC in China, the Japanese Patent Office, they follow a very similar step process, a very similar line of reasoning, which also confirms that it's probably a good best practice to employ globally. The US still remains vastly different. That's also because of the legal system, and they do it their own way. But what you would, if you would be following what the European Court of Justice has basically mandated, you will not hurt your position in the US. So we believe it's just good to implement all of this globally. So what did we do? To us, it seems that on the licensing side, the most important part is providing a lot of information, building your case towards the licensee and try to get a resolution amicably first. So what we do is we looked at our terms, we tried to simplify them, make sure that a business person can read them and not only lawyers. We increased transparency a lot. Let's say with a 90s mindset, it was mostly keep everything to your chest. We put it all out in the open right now, so we put everything on our website. Our terms are on the website. We put on the website something we call patent brochures, which is basically a table mapping each claim of the standard to particular sections of the standard, and we put it out there as well. We provide claim charts and bilateral discussions, which are more detailed claim to standard mappings. And we provide on our website also an explanation of the royalty rate, and when we're in discussion, we can even go into further details. Another thing what we do is we are very available, so with any kind of licensing discussion, we make sure that engineers are available, we got local presence. We usually got people, at least in China and in Japan, who also speak the local language, who can explain our positions, can explain the patents. And we commit to FRAND, obviously, but that mostly means for us, apart from all the other stuff that we already do, is that we make sure that every license that we offer fits in the same framework of making sure that all the licenses are comparable. So we make sure that we treat apples like apples and oranges like oranges. So just some examples. This is our website. All these are links to all these materials available to everybody. In our discussions, we also use industry reports, for example, where sometimes we're mentioned. Does this have a pointer? Yeah, so here we're mentioned. So where we compare to other efforts, so hopefully also convincing companies that, look, we've done our bit and now it's yours. Time for yours. Because in the ECJ decision, and also something which has been actually growing in Europe for a long while already, like in the Orange Book decision in Germany and the Philips SK Cassetten in Holland, it's a recognition that FRAND licensing should be what they call a two-way street. It's not only the licensor who's got obligations and obligations and obligations and obligations, and the company implementing the patents can just sit down, relax, and just wait until you ticked all the boxes and then say, well, I want to have a license or not, or I'm not going to pay you anything, or I'm going to pay you what you're due. So what this basically says is that there's an obligation both sides. It's something which may be growing a little bit, but in the industry, there's still a huge incentive not to comply. So what we see is that this framework is used a lot to throw up a lot of questions. And Telly will go into a lot of the recent decisions and recent court cases as well, where you will notice that these 4 simple steps have evolved into a framework, basically a tree of obligations mostly on the licensor to justify its positions before the infringing side actually has to do anything. So what we still see is that holding out is rife. Most of the market is holding off. They ask for more information usually, and like I said, this can draw out a licensing discussion well beyond 2 years, sometimes even 4 if the company is large enough. And in the meanwhile, we all know how many phones there are. I think that the average lifespan of a mobile phone is between 10 to 14 months. Most of the global population's got a smartphone, so you can count up how many counts of infringement there are. And the longer you wait, the more difficult the discussion gets, because the due royalties will amount as well. And again, that's an incentive, because if the past due royalties are reaching an amount where, if you look at it from the outset, looks unreasonable, licensors will tend to diminish the rates. So the longer you wait, the better you will, the better negotiation you will have for your company, because basically parts of the infringement will be waived or ignored, etc. So that's a difficult balance that I have to work with every day. What is the solution for this? For us, we only think that a patent can be as strong as can be as strong as the injunction it represents. So eventually, a patent is a right to take somebody out of the market who does not take a license or who basically infringes your patent. We do carry a policy of whisper softly and carry a big stick, but if somebody takes your stick away, I mean, whisper softly is not going to cut it. So just some examples, and then I'll leave it to Tally, I think, but just to make it visual, in an ideal world, everybody's got efficient transactions, the patents are grouped together, everybody's transparent, the total burden is transparent as well, because that's also an issue right now in the industry. Some parties do not disclose what their royalty rates even are. So if you're going to start making a mobile phone, well, you got Cisco, you got Via Licensing, who's got a licensing pool as well, you got maybe Ericsson, who publish their rates. But that's maybe 50% of the market, 60% of the market. What is the other 40% doing? So they don't know what the total royalty will be, and so they don't. So there's also a little bit of a lack of transparency in the entire field. But in an ideal world, everything is transparent. There's efficient transaction. Everybody pays their licenses. It's click in the basket, and they go and they put their product into the market. Now, actually, what we do see is that free riding, there's a lot of incentives for free riding, especially what we hear in some of our discussions with people who source their products. They say, well, we get the advice not to take a license, not to even to talk to you, and just wait and see. And it's for some companies a very effective policy, because it means that they get to increase their margins or suppress their prices and compete, let's say, on an unfair playing field with the companies who did the investment in R&D. And therefore they can sell the products for cheaper and they can gain market share. And they will say, well, once we're a vested player, we will see then what we'll do. We'll take a license or we won't, depending on the field. And what this encourages is that people talk in the industry, they look left and right, they see he's not paying, or they hear he's not paying, and then their management starts to ask their IP department, why are we paying? Or why are you even talking to these people? And let's do what they are doing. And what we've even seen, we've got an office in Hong Kong, and we like to keep a close ear to the ground. What we see is that there's actually conferences organized to explain to the industry how you best can efficiently infringe, like they call it. So they got conferences where they explain how to draw out the process to the maximum amount of time, and hopefully to get to basically licensing companies to either give up, or to see, well, am I really going to be first in line to be litigated against? And that has been shaping this situation for us a lot. And of course, the companies who do pay, they stand there and they are asking themselves, am I doing something wrong? So part of our mission, of course, our mission is also financial. But part of our mission to achieve that is to level the playing field. I mean, World Championship is just starting. If this would be the pitch, nobody would like that, I guess. So we think that with patents, with the innovators on the low ground, and the implementers, the pure implementers on the high ground, patents can actually level the playing field by creating a fair framework for licensing. And this is just, let's say, a summary of what I said before. I'll leave it with that. I'll leave it to Tally to follow up. She represents the other side sometimes, I hear, so...
Thank you very much. So we'll take questions later.
Yeah, I would say questions after Tally.
Thank you, David, and thank you, Joita, for the introduction. I am going to talk a little bit more about the cases that we have seen in the UK and elsewhere. But actually, before we get to that, we have here an opportunity where I understand there are pharmaceutical and life science lawyers in the audience. And something I always wonder, we heard David talk about intentional infringers, holdout, not taking a license. Is there any sort of mirror or equivalent on the pharma side where a pharmaceutical company has a patent and complains that the infringer or the generic doesn't want to take a license until they have gone to court to actually prove their patent is valid? Is there any sort of...
Usually I will want to fight it out
Yeah.
and hold out as much as possible, and invalidation is one of the first points of attack.
The patent invalidation?
Yeah. At some point there will be a mutual settlement. I think it doesn't often, some of the cases don't actually conclude, and it makes it sort of worthwhile just to settle.
Yeah.
But no, it's nothing in this scale, and also by the time a product gets to market, the patent life is so much reduced as well. So for generic, they could even hold out until the patent expires, whereas I don't know quite how much patent life would be left in these types of cases.
Mm-hmm. Yeah, well, that's interesting, and maybe that's something we can come back to at the end. But I'll jump into the case law. As Joita mentioned, I'm a senior associate at Allen & Overy. I don't have A&O slide. To be safe, I'll say that all views are my own. A&O is a firm, international firm.
Likewise, by the way.
I think that at last count we have 44 offices in 33 countries or something along those lines. The IP group practices internationally. We have a big department here in London, France, Amsterdam. We have a couple of offices in Germany. We're active in China. And we do IP litigation, both patents and brands work. David had mentioned the Huawei ZTE case, and I wanted to touch on it just briefly, or just to recount. As David had mentioned, this is kind of the keystone case that came out of the ECJ, setting out how implementers and SEP holders should behave in their licensing, and what protocol and what criteria there are to be able to get an injunction. Because as mentioned, in Europe, you do generally get an injunction. However, the question was, can you really get an injunction on a patent if it's a standard essential patent? And the ECJ says yes, so long as you behave according to the protocol. And just broadly speaking, the protocol says that a SEP holder has to make a FRAND offer, has to indicate what its patents are, and the implementer, the licensor, will then make a counteroffer, evaluate, and that counteroffer should be FRAND as well. And that counteroffer needs to be timely. You can't delay, you can't hold out and drag things out. You have to behave in a FRAND-like manner. And this is the judgment that came out of the ECJ back in July 2015. What that means is still up for grabs. We've seen the German courts interpreting it one way. We've seen the UK courts interpreting it another way. And it's led to, as David said, for 15 years, still nobody knows what FRAND is. I think now we also don't quite know what is FRAND behavior and what is one supposed to do. So I'll talk a little bit about the main judgment in the UK, which is Unwired Planet. Are people familiar with this, Unwired Planet versus Huawei? I'm seeing some nods. I have one slide, but I'll give a little bit more background. This case, I think, initiated in 2014. Unwired Planet had purchased patents from Ericsson. As David mentioned, we had Ericsson, Nokia, a lot of these parties had participated in standard setting, had then sold off some of their patents. Unwired Planet is one of those entities that bought the patents and had brought suit against Google, Samsung, and Huawei in 2014. They ended up litigating against Samsung and Huawei in the UK and Germany to determine validity and infringement of the patents. And a number of the patents had been found valid and infringed by Samsung and Huawei. In the autumn of 2016, there was an 8-week trial to determine the FRAND rate for Unwired Planet's portfolio. Prior to that, Samsung had settled. This was interesting because the settlement between Unwired Planet and Samsung was deemed to be a comparable license by Huawei. However, Unwired Planet argued that's not a comparable license. So after an 8-week trial with experts on French law interpreting what is the Etsy obligation, economics experts, competition experts saying what is competitive behavior, anti-competitive behavior, Mr. Justice Burst gave judgment in April 2017. And the main points are that even though Huawei ZTE says, well, one side makes a FRAND offer, the other side makes a FRAND counteroffer, indicating there might be a range of FRAND rates, Burst said no, there's only one FRAND rate for any given set of circumstances. And in the case of Unwired Planet and Huawei, that is going to be a global license. Now, this was the biggest issue in dispute, whether Huawei has to take a license just for the UK patents that it has been found to infringe, or whether it has to take a license globally. And Burst said it has to be a global license. These two multinational entities operate globally, and therefore any sort of license that they would reach would be a global license. Additionally, the court had looked at comparable licenses, which is a way often of getting FRAND rates. And by and large, all comparable licenses, all licenses in the industry are going to be global. When two parties come together at arm's length and reach a negotiation, they're not going to settle things one country at a time. They're going to have a global license. It may vary depending on the jurisdiction, but by and large, comparable licenses tend to be global. And so the court found that it too was going to set a global license, and Huawei could either accept that license or face an injunction in the UK. The offers and counteroffers made by both sides, Burst found that those were not FRAND, and that they don't have to be FRAND so long as there's a FRAND intent, and the party thinks that they are FRAND or close to FRAND and wants to make a FRAND offer or counteroffer, or agrees that at the end, once the court decides it, after an 8-week trial or at whatever procedure, the party is willing to accept those FRAND rates. And there's no single method for portfolio evaluation. The method used was comparable licenses. Another approach that's often used is called the top-down approach or total aggregate approach. We mentioned LTE or 4G, so there's X number of LTE patents out there. Now, how many patents are owned by Unwired Planet, how many patents are owned by Cisco or any other entity? You kind of look at those numbers and you say, well, how much percentage of the price of my phone am I going to be paying for LTE patents? So Burst found as a cross-check that about 8.8% of the total price of your phone will go to licensing. And so that a smaller proportion of that would go to Unwired Planet because they owned just a small proportion of those patents. What proportion do they own? This was the big issue because even though they had demonstrated that 2 patents were infringed, Unwired Planet said to have 6 LTE patents, 6 that were actually truly essential. Does the phrase truly essential mean anything?
Redundant.
It's redundant. And the reason it's redundant, or it should be redundant, is that a patent is declared essential, therefore my phone will not operate without it. It is standard essential to operate the 4G standard. I absolutely have to have this patent. However, we often have a problem of over-declaration, where patent holders want to declare a lot of their patents to be essential. And so if you actually look at the patent and you compare it to the standard, you end up finding that actually maybe this patent is not truly essential. And that's where and I put it in quotes, that's where that concept had come from. So even though Unwired Planet had more than 6 declared LTE patents, it was found that the actual essential patents they had were 6. But 6 out of how many? How many LTE patents are there globally? I asked sort of, not that there is an answer. Burst found that there's 800, and the way this was done took 6 months. Both sides had different methodologies for presenting how it was done. Huawei actually hired a team of experts in India to go through every patent that had ever been declared essential and review it and decide was it essential or was it not. This process took 6 months. I think it came out to half hour per patent, which was questioned at trial, whether that's really something that's sufficient to evaluate a patent and decide if it's essential. The number they'd ultimately come to was about, well, there's 1,800 that are truly essential. Unwired Planet said, no, it's more like 350, 355. Burst sort of halved one, doubled the other, and split the difference, finding that there's 800. And saying that that sounds approximately right. So The result is that Unwired Planet has 6 out of 800 LTE patents, and therefore the royalties they should get are commensurate with that. No, that's jumping to the appeal. The way that proportion relates to rates is actually by looking at Ericsson licenses. Why Ericsson? As I mentioned before, Ericsson had owned these patents previously. They were sold off to Unwired Planet before. And so all of the Ericsson licenses were examined. Some were found to be comparable, and Burst was able to look at those licenses and say, well, here's the rate. I don't have it on the slide, but it actually works out to 0.052% of the price of the phone in the UK. If you can imagine what that is, that's if a phone costs 300 or 400, it comes to about, is it 17 pence? I'm sorry. I'm happy to work out the math for you if you'd like, but it works out to a certain amount of money per phone. The big issue wasn't the amount, it's does Huawei have to pay that for every phone sold in the UK, or does Huawei have to pay that for every phone sold anywhere, or be injuncted in the UK? And the answer was the latter. This, maybe not surprisingly, was appealed, and there were 3 grounds of appeal that went before the Court of Appeal, which had a hearing for 6 days in May. The first was the global licensing issue. Can the court really order a global license? Does the court have jurisdiction to make me pay for patents in the US or France or China, which I may or may not be infringing, but which has not been determined yet? The second point was called hard-edged non-discrimination issue. Both RAND and FRAND, there is this element of what is discrimination, and as I mentioned, Samsung had settled out of the case before it went to trial. And the Samsung license, we don't know the details, it's confidential. However, we do know that it was better terms than Huawei was offered. Why? Because Huawei asked for those terms and was denied. Unwired Planet had said, well, this license with Samsung, this was a settlement out of the trial. At the same time, Unwired Planet had been sold off to another entity, Panoptis, and said, this was a situation of a fire sale. We weren't getting any royalties. We needed to settle something. This is why we had this deal. This is simply not a comparable license. And Mr. Justice Burst found that to be discriminatory, the rate has to be so off as to actually impact the party behavior in the market. This is a little bit different than how other courts have viewed discrimination, where they say, well, if 2 parties are similarly situated, they should be getting similar rates. So this was the second big point of appeal. And then the third was the Huawei ZTE protocol. Did Huawei actually follow this dance or protocol that comes out of the ECJ? And one dispute is, well, is this really something that needs to be followed? Is it enough to get at the FRAND result at the end? And Huawei's main point on appeal was that the ECJ set this out as pre-action protocol, sort of a licensing framework for parties to behave to avoid litigation, to actually be able to get at a decision, get at a resolution before going to the court. And their main complaint was that Unwired Planet sued them before actually making any offer. So we'll see what will happen with this appeal. I attended the Court of Appeal hearing for 6 days last month. It's very interesting. I think global licensing may end up holding. We'll see, but remains to be seen. So before I jump into the UK case law, I'm just going to go across the continent to TCL Ericsson. The reason this is interesting is this is the big judgment that came out of the US California court last year, in which the court found, A, that the global licensing was appropriate. Why was it global? Because both parties had come forward and said, we want you to determine a global license. Both parties by agreement had said, yes, we think it makes sense to do a global license. Why would the defendant do that? Why would TCL do that in that situation? Any thoughts? Well, this was a lawsuit where, not unlike many other suits that involve FRAND disputes or even pharmaceutical disputes, the case had been brought in several different jurisdictions. Ericsson had sued TCL in, I believe it was Japan, China, I don't know if the UK, but certainly in the US. And TCL had come to the California court and said, look, we don't want to fight this everywhere. It doesn't make sense to fight this everywhere. We agree that you, California court, can set a global license, and we will accept it. We ask you to do an anti-suit injunction and stop these other lawsuits from going forward. And that's indeed what happened. However, if you look at the rates that were found in TCL v. Ericsson, this is a good comparator to Unwired Planet. The reason is, although Unwired Planet rates were for Unwired Planet's portfolio, because those patents had come from the Ericsson portfolio, it was necessary to also determine the appropriate rate for Ericsson's portfolio. And if you see the purple, that's the rates that Burst had found. And the other colors indicate the rates found by the California court. Now, the court had found 3 different regions: the US, which should be the most money, the Europe, which should be slightly less because there's less patents, and then rest of world. But all of those, if you can see, compared to, are far lower than what has to be paid in the UK. So what happens with that? What's the likely result if you have a court in the US or perhaps China giving rates that are much lower than the UK court? What are parties going to do going forward? What would you do? David.
What would I do?
Yeah.
Well, first I have a question. So, in the appeal, so you were there. The portfolio license was not challenged?
The actual rates for the portfolio were not challenged.
No, but also the fact that you have to take a portfolio license instead of a patent-by-patent license, which also is an argument in lots of discussions.
Yeah, and that wasn't challenged. And that, up until the FRAND trial, Huawei had first said, look, we've infringed 2 patents, give us a license for these 2 patents. They were then willing to say, give us a license just for your UK portfolio. So they had effectively dropped the request for a patent-by-patent license. So it was really between UK or global. And so on the appeal, they appealed the global issue, saying, look, we really are happy to take a UK-only license, even at the rates that were found, but we shouldn't be paying for the whole world. Whereas the court said, well, globally, all comparable licenses are global, and if the SEP holder has an obligation to make a FRAND offer under Huawei ZTE, why shouldn't that FRAND offer be global?
Yeah, and it's also the question, I think, from a judge's point of view, if you just settle for this one jurisdiction, you don't settle the dispute.
Exactly.
So the parties are still fighting. You just took this little...
You just carved out the dispute.
Yeah, exactly. So it's not, I mean, from a judge point of view, that's not very appealing, I would say.
Yeah.
Based on those figures, I would not go to UK.
So what I'm getting at for likely outcomes is that if the UK is going to give you higher rates than other courts, then if you're a SEP holder, you're going to run to the UK court. That's going to be your preferred court. And you're an implementer, you're going to want to get into other courts, for instance, the US, or if you're Huawei, the Chinese court. So we have a race to the courts, essentially. However, it's very hard to do a race to the courts if you also have the obligations as set out in Huawei ZTE. And why is that? Because Huawei ZTE tells you how you're supposed to operate pre-action. So if you get a hint or a whiff that you might be sued and you run to the US, you're not operating according to Huawei ZTE, and that could be held against you, and you might be injuncted in a European jurisdiction. So rather than race to the courts, what we have seen are jurisdiction challenges and anti-suit injunctions, which I kind of think are the flip side to each. As mentioned, SEP holders will want to bring their actions in the UK, implementers may not, and so where will these actions to determine global FRAND rates or to determine FRAND rates generally be determined? Before I get into a different case that we acted in, are there any questions about Huawei ZTE, Unwired Planet? Yes?
So I understand sort of some of this, but if half of the sales are covered by the patents in patented countries, and half of them are not patent covered sales, they're in Brazil, India, Malaysia, once you determine the FRAND rate for a reasonable license of a patent covered sale, shouldn't a global license that's imposed out of that be discounted by 50%?
Should you not have to pay for countries where you're selling phones, but there are no patents?
Right.
Yeah. So according to Burst, you still have to pay. According to the Unwired Planet judgment, if there are countries like Venezuela where the implementer is selling phones, however, there are no patents in that country, you look to the country of manufacture. And in the case of Unwired Planet versus Huawei, Huawei manufactures its phones in China. Unwired Planet does have patents in China. So because the country of manufacture is China, even though Huawei is then taking those phones and selling them, say, in Australia or Brazil, countries where there are no patents, they still have to pay a royalty because the phones are manufactured in a country where there are patents. It is at a discount rate, it's at half price, but you still have to pay a rate under Burst.
Okay, but I'm still confused because if you look at standard essential patents, probably all of them you're going to have a US patent for. 75% of them you're going to have a European patent that covers some European countries, validated it in UK and Germany and Malta or something, and 10% of them are going to have Chinese patents. So saying a Chinese sale is covered by all the essentials patents, that's not right either.
Well, I think if you that's a very US-centric approach, I would say, because if you look at
just trying to be reasonable.
No, but if you look at mostly, for example, companies like Ericsson, European operating companies, I think that Chinese portfolios have been vast. So 10% is a bit off, I would say. I would say at least 50% or more. And I think current practices are you always file your patent in China as well, because that's where the base of manufacturing is. Just like, for example, in telecommunication, you had this weird situation that most portfolios got a Finnish and a Swedish patent, because Ericsson and Nokia used to produce in Finland and Sweden.
All right, so I think if we were to try to generalize it, if generally standard essential patents are in China, Europe, and the US, in its somewhat even distribution, then you can just ignore that. But how do we know that they are?
Yeah, that's one of the big questions, I guess.
And in this case, just jumping forward to this next case, Conversant, it is a patent portfolio of 2G, 3G, and 4G patents. However, Conversant does not have any 2G patents in China. And so they're not claiming rates for 2G patents in China or in any countries in which they don't have patents.
Do they have 2G patents in the UK?
They do.
They're all set.
Yeah. Just before jumping to this case, what I find odd about linking some rates, some royalties that you have to pay to manufacturing, but then other royalties you have to pay to sales, is that it really is dividing it. All of the manufacturing happens in China. So if you're going to pay royalties for manufacturing, you should pay the China rate, which is half price, for all manufacturing. And it shouldn't matter if you're selling your phone in Australia, where there are no patents, or in the UK, where there happen to be 6 patents. However, the Unwired Planet judgment does a blend, where you're required in those countries where there's patents to pay a higher rate, but you're also required in those countries where there are no patents to pay because manufacturing happens in China. So just jumping quickly to this other case, Conversant versus Huawei. Conversant is another entity that has purchased patents not from Ericsson but from Nokia and had sued Huawei and ZTE in the UK court. They brought the case July 2017. Asking for a global FRAND rate, asking that the rate be determined as compared to the rate in Unwired Planet, and stating that 4 of their patents, their UK patents, are valid and infringed. Now, defendants had brought a jurisdiction challenge to this case. Why? There were 3 different grounds. The first is justiciability, saying if you're going to determine a global license in the UK, it doesn't make sense to do it at a place where only 1% of the patents are in the UK, 1% of the sales are in the UK. But more importantly, the UK court does not have jurisdiction to set a global license or to require or coerce, as some words are used by defendants, to require a implementer to take a license in such countries as the US or China or Australia, where there are no patents or where there are patents that may be invalid, where Conversant does not have to demonstrate that these patents are valid and infringed. That was the first ground. And that is similar to the argument that was advanced in the Court of Appeal for Unwired Planet versus Huawei. The second ground is forum nonconvenience. Basically, Huawei does all of its manufacturing in China, and the majority of sales are either in China or in countries where there are no patents. Therefore, all of the royalties, or the majority of the royalties that will be collected, derive from China activity, and therefore are contingent on China patents. Therefore, the court that should be setting this is the China court. This court, the UK, is not a convenient forum. Why? Only 1% of the sales is in the UK, and there's very few patents here. And then the third was a specific issue relating to service. Huawei China does not operate in the UK. However, service was done on a different entity, Huawei Global Finance. Ultimately, the court, Mr. Justice Carr, dismissed the jurisdiction challenge. We won on the last point. Service had been improper, and so service had to be redone. However, rather than go through The Hague and rather than wanting to slow things down, the defendants were willing to accept substituted service, accept service through their lawyers, effectively. But on the other grounds, global FRAND is totally justiciable. It can be done in the UK. And part of the reason for this is that we already have the Unwired Planet judgment. From Carr's point of view, and generally from a UK High Court judge point of view, unless there's reason to think that it was actually absolutely wrong, you follow the precedent as set by the other judges. So even though it's on appeal, the current precedent is Unwired Planet versus Huawei, which was able to find a global license. On the second point, Mr. Justice Carr found that China would not be a suitable alternative forum, and therefore you can't send the case to China. Why? It was questionable whether the Chinese court would set a China-only FRAND rate or a global FRAND rate. And part of the argument and part of the difficulty was saying, well, global is non-justiciable anywhere. No court should be doing it. But if any court is going to do it, it should be China. And part of the problem with this is global license we argue global license brings into it determinations of foreign patent validity. If you're going to make me pay a global license, that means that the French patents are valid and that the US patents are valid and the Chinese patents are valid and infringed. However, we say they're not. And you can't do determinations of foreign patent validity in the UK court. Patent validity, as opposed to infringement, must be determined by the local court. That's how Brussels regulation works. However, in China, therefore, Chinese court would not be able to set a global license, even though the defendants were willing to say, look, we'll only care about the Chinese patents. We're willing to use this to extrapolate to a global license. It was not clear that it would be possible for the Chinese court to do. The Chinese court had never done it, never set a global license. And we were saying that only if the parties agree for a global license, then the Chinese court would be able to do it. Because of that, Carr said that isn't a suitable alternative forum, and so the UK was the forum convenience. And on service, as I mentioned, the service will be redone, but through substituted service. This case is being appealed, so what happens with the appeal, how it's tied to the Unwired Planet appeal, how it gets impacted by what results we see out of Unwired Planet, all of that remains to be seen. Are there any questions on this case? I'll just touch quickly on a couple of other cases because the subject of the talk was to be jurisdiction challenges and anti-suit injunctions and really the sort of jurisdictional mess we get out of Huawei ZTE and courts setting FRAND rates, global or not. A few other cases are Apple v. Qualcomm and Huawei Samsung. Apple v. Qualcomm is being litigated in, I think, 6 different countries, including in the UK. And Qualcomm was first sued in the Southern District of California. And it said, look, we're here, Apple is in California, they sued us here first. How about we just do this case here? We can set a global license for the Qualcomm patents. Apple will take it, Apple will have to take it, therefore it does not make sense to continue litigating in other jurisdictions. The court disagreed. The court said, well, even though we could set what would be a global license, there's no obligation on Apple to take that global license. If Apple wants to litigate EU antitrust law in Europe or Japanese antitrust law in Japan and wants to litigate different patents' validity in other countries, they're free to do so. So that's an example where the motion for an anti-suit injunction failed. Compare that to Huawei Samsung. Huawei had sued Samsung in California and in China, different jurisdictions, asking Samsung to take a license to Huawei's portfolio, but asking as part of that for a cross-license to Samsung's portfolio. This main case, asking for a FRAND cross-license, is pending in the Northern District of California. However, at the same time, Huawei had brought patent validity and infringement actions in China, and Samsung had done the same for some of Samsung's own patents. Huawei won and actually was able to obtain an injunction on 2 of the patents in China. Samsung had gone to the Californian court and said, look, all of this is being litigated here. We're trying to determine the actual proper cross-license for our whole portfolio. Why are we being injuncted now in China for these 2 patents? It does not make sense. And Samsung won and was able to get an anti-suit injunction stopping the injunction in China. Are there any questions, generally?
No. Thank you very
Thank
much.
you.
So Are there some questions for David or Tali on any of the matters they discussed, or even in general, or if you want further explanation on anything?
Just a quick question. I'm Kevin Fournier from IBM. Can you explain the anti-suit injunction? It's a term I've not heard of.
It's on already.
I think
It's on. Is this on?
Yeah.
So an injunction to stop a separate lawsuit. So in this situation, there was a suit in the Huawei Samsung, for instance. Huawei was able to bring an action in China and actually get an injunction in China, and Samsung wanted the U.S. court to step in and prevent that from happening. And so they brought an anti-suit injunction, and they won. Basically, the injunctions in China were wiped clean. The U.S. court had stepped up and said, well, no, the Chinese court should never have granted an injunction, so we're going to stop that. Compare that to Apple v. Qualcomm. Qualcomm had asked the California court to grant an anti-suit injunction for the cases that were being litigated in Japan, Taiwan, China, the UK, a few other jurisdictions. Basically asking, you know what, this is being litigated in 6 different countries. We don't want that. We want it litigated only in California. You, California court, have the power to grant me an anti-suit injunction and therefore preventing those other suits. They lost. That was not granted. And so the litigation continues in 6 different countries.
Okay, so one country can stop injunctions that were granted by another country.
Yes.
Wow. Okay.
Well, I guess that the Chinese injunction would still be active. The point is that there would be consequences for your business in the U.S. So that's basically how it's construed, I think.
Yeah, as well as contempt of court. If the U.S. court orders you not to pursue this injunction in China, but you do, you're then in contempt of the U.S. court.
It's a bit overreaching, though.
Yes,
Oh my
absolutely.
goodness.
Unlike all the other parts of this.
So I have a quick question for David on the licensing side of things. So you mentioned a tree of obligations for the licensor. Does that include the know-how side of things as well? Bearing in mind I'm from the pharma background, is there quite a lot of know-how that the licensor will need to help the licensees with, or is that covered in your licenses? Or
Well, that's part where it gets complicated. So, for example, if you look at German litigation, the Germans took it upon themselves to give a lot of explanation to all these different steps. So, for example, some courts, and even in a country like Germany, the various courts got different opinions as well. So, for example, the Düsseldorf court has said you have to disclose proactively all your existing licenses, even if they are subject to confidentiality. The Mannheim court says, no, well, you don't have to do that, but you have to provide more detail about how the patents are infringed. The Düsseldorf court, for example, there says, well, you have to provide claim charts. The Mannheim court says, well, you can just give a general overview of the relation between these patents and the standards and rely on that, and then see in negotiations where you get. If you go into other jurisdictions, again, the level of information to be provided is different. So what we've been doing now is we just give everything.
right.
And what we also do is we make engineers available to explain these patents in person in meetings, etc. We find that to be best practice, but it's difficult to determine what is actually your obligation, because these judges, they all take different approaches depending on their seat. So we do see that the seats are fairly consistent, but there is some sort of friction in Germany, which is about to be resolved probably by one of the higher courts now. And I can imagine the same happening in the UK, soon to be probably in the Netherlands. We don't know what's going to happen in France, for example, or Spain. So yeah, that's something that's going on. And it's mostly on what is the FRAND offer. So what a lot of the courts say, well, if you didn't provide this information, you cannot consider that your offer was FRAND to begin with. Even though the economics are completely fine, the patents are valid and infringed and whatever, if you didn't explain yourself correctly, the offer was not FRAND to begin with. No.
Quite complicated. Thank you. One question at the back there.
I have a further question on that regard. So I'm Timo from MRHIP in Munich, and of course you know the Cisco hire case. I would have a question in this regard, whether you have adapted your, so what you showed, how you go on with your licensing offers. Have you adapted your practice onto this judgment, or are you still awaiting for the further Supreme Court decisions to elaborate on your licensing procedures?
Yeah, just to give the crowd a little bit of an impression what Cisco Hire is, it's a case we started in Germany a few years back, even before the ECJ decision. So we didn't know about most of these obligations yet. But the outcome of that decision was that they compared our license history, and they came to the conclusion, well, there is some incompatibility between these licenses, so your offer was not FRAND. And we are in appeal to that decision. But we did adapt our license offer just because we know that going into appeal will take several years, and we'd rather go forward with the business while this goes into appeal, but already adapt to this kind of decision because it just makes business sense for us not to hold up our entire business. That was, by the way, on one particular portfolio, which is about a third of our efforts in wireless technology.
So just a quick question for Tally, actually. So we mentioned that in comparison with the pharma industry, there's not much patent life left for to recoup the return on investment and the returns. What is the lifespan for a typical patent in this field? So when does it get granted, when does licensing get taken, and how much time is there to recoup the value from licenses?
So for both the Unwired Planet Huawei case and Conversant cases, these are the two UK cases, the licensing was for 2G, 3G, and 4G patents. Now, 2G standard, I think 1998 was the release. We have some patents in these portfolio that are either expiring this year or expire next year. And it's technology that's very old. However, even if you have a 4G phone, if you're not in the range, it will drop down to 3G, it could drop down to 2G. And so if there's patents or inventions such as handover technology, handover from base station to base station, that date back to 2G, that technology might still be relevant today. So this is an example of very old patents that are still part of the portfolio that royalties would still be paid on if the patents are valid and infringed.
Right.
And the latest I've seen it is go to 4G. 5G is now being developed. I think it'll be at least a few years before it's being litigated in this context.
Okay, so it's got quite a long-term
Yeah.
patent life still left.
Yeah, and what you also see when people are talking about 4G or 3G or 2G, it's not a technology which is set in stone from its inception. So, for example, with LTE, we're currently at release 15. So that means that from 2008, if I remember well, when it was basically launched, until today, there has been 15 different versions of the same technology, which basically builds as building blocks on the previous versions. So the LTE, which was in your iPhone 4 or 5, I think the iPhone 4 did not have 4G, but that's a completely different LTE as what's in your current iPhone X. So back then, LTE was about a quarter of the speed of Wi-Fi, and currently LTE is much faster than Wi-Fi. Right. So even though an LTE patent can, for example, be already nearing expiration right now, because also part of 3G was transported into 4G, it could be the case that you got a patent granted today, which is essential to LTE. So it differs a lot. So what I generally see is that the average life of a patent after the go-to-market varies somewhere between 5 to 10 years, something like that. Yeah.
Right. It's not bad.
To follow up on that, though, if there is a portfolio of standards essentials patent, for that standard, those patents should be aging out over time.
Yeah.
Does the royalty rate lower over time?
So what you actually see is that patents expire and patents get granted in these portfolios. So they always kind of maintain the same level, and actually in a lot of cases they grow. So that's what we see with our partners actually, that also if they look into their portfolios, they don't always know which patents are essential when they start licensing them. So they may start out with 10 patents, but they've said, well, we got 50 other patents, which are maybe essential, but we have to look closer at it. And that's also a cumbersome process to figure out. I mean, for example, if you're a company like Orange, and you weren't in that particular standardization setting, or the guy who went to standardization for you no longer works for your company, you may have a patent on a technology for 10 years before you find out, hey, this technology, I've got a patent on it.
Yeah, but a standard portfolio, I guess I don't understand. It can't last forever. 50 years from now, there's not going to be any patents
Oh,
that cover
absolutely.
2G.
No, that's where
So-
you're right, absolutely. Yeah.
So the number of patents overall over some long period of time is going to decrease.
Absolutely. And this, for example, will be the case for 2G, which is phasing out. GSM is already gone, more than anything. 3G is slowly getting, let's say, patent-free. I think that will last a couple of years more because also that standard has been developing. But what you also see is that the technology is getting more complicated. So LTE is vastly more complicated than 3G was. And 5G, I mean, if you start to look at who are the actors, who are the innovators, and where it's going to be implemented, you start to understand that this is an entirely new beast as well.
Yeah, but if I have to license the 12G standard, aren't I going to be saying, you know, why should I keep paying royalties on 2G and 3G and 4G?
Well, by then, those are all gone.
Just to give an example of how
Just like GSM is no longer a license offer with anybody anymore.
So what
I
the,
think.
the license in Unwired Planet does, I had mentioned in the UK there's 6 LTE patents. However, and in France there's 5. There's different numbers. Huawei is free to challenge those patents where there's a lot and, you know, say, well, this is actually not essential, or look at this, this is now expired. And so on a yearly basis, there could be an assessment of, is a country a major market country, a country where you have to pay top rates, or is it a country where you have to pay half price? It is not per patent, so if 2 expire, that doesn't necessarily mean that the rate you have to pay will change. But if 4 expire, for instance, it might.
And
Yeah,
just-
so basically what you see a lot in the industry is that you will say, well, you know, we know that this is so portfolio is almost like a living thing. I mean, it changes over time. We try to even out the average rate, which is reasonable over a particular period of time. And then when there's a renewal of the term, you would look at what is reasonable now in terms of what is the portfolio. So, for example, there could also be some very milestone judgments on the same portfolio, or for example, which invalidates half the portfolio, or maybe even grants an injunction on half of it, which also may impact the valuation in the future.
And just as a quick editorial comment, the patent system covers cell phones, so like 800 or 1,000 patents for the communication standard, few hundred or 1,000 other patents covering the other parts of the cell phone, whereas another valuable product like Lipitor might have 1 or 2 patents that cover it, and the same system has to make both of those work,
Yeah.
which is
Right,
part of why there's problems.
Thank you. If there are any more questions, I'm sure both David and Tally will be around over coffee. I think we're out of time. Thank you very much to our speakers again. And thank you for all your participation. And I think, is it?
Well, thank you all. It was really very nice session.